Australian journalist Julian Assange has for the past 10 years been eluding the US government, potentially facing counts for conspiracy, espionage and treason. Assange has found himself the centre of attention of governments around the world. However, 7 years in the safety of the Ecuadorian embassy has still failed to protect him. Now Assange finds himself behind bars in Belmore prison and fighting extradition to the US. Should the US succeed in overturning Assange's stay in the UK, what fate awaits him? To give us further insight into Assange's plight is Senior Counsel and Advisor to the Assange campaign, Greg Barnes. Greg, thank you so much for joining us here.
No problem, Natalie.
Now, first of all, I guess the question is, how is Assange holding up both mentally and physically?
Well, it's no doubt that Belmarsh prison has been a very difficult place for him, as it is for every prisoner, but particularly in the context of COVID. There's been a lot of solitary confinement, inadequate clothing during the cold English winter, and his mental and physical health has deteriorated over a number of years, as we heard during the extradition proceedings last year. But he is remarkably resilient and has been for a number of years. And has strong support, of course, from his partner, Stella Morris, and his two young children, and also his family in Australia.
And is he receiving any sort of counselling while he's in prison?
Well, I'm not sure, but certainly, a person with the sort of health issues that he has needs to be out of prison. It's very difficult to get better while you're in prison, even in the best of times. But certainly with his mental health, which has deteriorated, and evidence was given about that. And in fact, that was the major reason why the judge in London refused to extradite. He needs support, and he needs that proper support outside of the prison system.
And given everything that he has endured to this point, has he ever considered giving in to the American government?
Not at all, and rightly so. This extradition has been fought from day one, and he's been vindicated in his stance, certainly up until this point. We'll see what an appeal court does, but he's been vindicated. And he's been vindicated for a reason. All he was doing what other journalists do, that is to get information from sources, publish information that was embarrassing to the United States. But that's not a reason to charge a person as he's been charged in this particular case.
And what are the charges that the US government are preparing?
Well, in essence, and you described them in your opening, but in essence, there was a hacking charge to start with, and then there was some trying to use US espionage laws to say that what he's done is break the law by revealing secret material and working in a conspiracy with others to do it. What's dangerous about this for journalists is that this is the first time the United States has sought to use its domestic espionage legislation to go after someone who has no link to the jurisdiction. He's not an American. He's not an American citizen. He's got no ties to the United States. And if the United States is successful in this case, it will mean that any journalist in the world who publishes material which the United States deems to be embarrassing and which may previously have been under lock and key, will find themselves on the end of an extradition request in similar circumstances.
So I guess you've kind of answered the question, but I'm going to ask it anyway. How true are the charges?
Well, they're not true at all. I mean, in the sense that what the United States is saying is that he conspired to commit illegal activities. What he did was, of course, perform the function that is performed by investigative journalists around the world, and that is to speak with sources about obtaining material. We've had a number of journalists, very senior journalists in Australia, but also around the world, who've said, look, and there was evidence given in the extradition proceedings, look, what he was doing was no more than or less than is done in other circumstances. So the charges themselves, leaving aside the freedom of speech arguments, which are relevant to the case, the charges themselves are absurd.
And would the charges hold up in an independent court, so outside of US jurisdiction?
Well, I think very doubtful, and certainly in parts of the United States, perhaps not. But the difficulty with this case is that he's going to be tried in Eastern Virginia. This is a setting where jury members are drawn from the families of people who work for the CIA, the FBI, and other institutions, because it's close to Washington. There's a very strong chance of conviction in that particular court, and it's inconceivable that he would receive a fair trial.
Would he receive a fairer trial in another state of the US?
Well, again, I'm not sure about that, and that's subject to conjecture because the case has to be brought in Eastern Virginia. But I think the point is that he would be able to argue and should be able to argue that he has First Amendment protection. In other words, as you would know, the United States, the freedom of speech amendment to the Constitution enables journalists, for example, to say that they've got that protection when it comes to publication of material. That's the reason why the US government didn't go after Assange's partners in the publication of this material in 2010, 2011. That is Washington Post, Guardian, Der Spiegel, some Australian newspapers. They haven't gone after them because they will use the freedom of speech protection. Assange ought to be able to use it because despite what the US says, he's a journalist and he ought to be able to use it.
Now, switching gears a little bit, the Australian government continues to fail Julian Assange and has done so since 2010. Has anyone from the federal government reached out to Julian or to yourself or any of his team?
Well, I think it's fair to say that the closest we've come to that is when Julie Bishop was Foreign Minister, rightly allowing Julian to renew his passport, giving him a new passport. But it's also fair to say that it's been a disappointing response from the Australian governments since 2010. You have an Australian citizen who faces an effective death penalty because if he's found guilty of these offences, he could go to jail for up to 170 years. You now have a finding of a court that if he goes to the United States, he's likely to be an extraordinarily high suicide risk to the point where he'd probably die. One would have thought that was enough to get an Australian government involved in the case with its closest ally. I mean, we have Australian governments get involved in cases involving people who get into trouble in Indonesia, in China, in other parts of the world. This is our closest ally. This actually ought to be an easier case for the Australian government to involve itself in.
And why are they failing to assist him? I mean, he's one of their citizens. No matter how much research I did, I couldn't find the answer to that.
It's politics, and it's a lack of preparedness and a lack of courage to say to the United States allies, look, you need to move on this. You need to end this matter. We did it with David Hicks after enormous pressure was placed on the federal government when John Howard was Prime Minister. We ought to be doing it again in the context of this case. Bob Carr, the former Foreign Minister, has made this point quite eloquently on a number of occasions over the past 12 months. Kevin Rudd has made a similar point. And so, these are decisions which are purely political. If Scott Morrison and Maurice Payne wanted to speak with the Biden administration, the incoming Biden administration, within the first week and end this matter, I'm sure they could do it.
I mean, again, I think this question's already been answered, but is it acceptable what the Australian government is doing or lack of action?
Well, I think it's unacceptable because not only in Julian's case, but what it shows you that in cases involving security and the United States or other allies, an Australian government won't protect that citizen and won't protect the rights of that citizen, but also protect that citizen from harm. And that is a very, very dangerous precedent. And so it has broader implications.
Greg Barnes, we have so much more to talk about, but we are going to leave it right there and we are going to be right back with part 2.